Hey, how you doing? This is Adam Post. Target panics as fraud lawsuit over Pride Month gets worse. Everyone remembers Target went crazy with Pride Month. They didn't just have a couple of displays. They pretty much turned over their entire store, at least the focus of their entire store, for like all of their stores, to promote Pride Month. You know, if you want to do something like that, you better be a privately owned business, or you better legitimately not know that this is taking a big financial risk with the value of the company. Because investors, having seen this, got a little bit angry because they said, you know something, you knew this could be a big problem for the company. You didn't warn us this could be a big problem for the company. And the company's like, well, you know, Pride Month, we're going to change some of the displays. We're going to pull some of the merchandise. They did respond eventually and dealt with the issue, but investors did lose money over this. The stock went down, and some investors were more than insulted. They were angry because they lost money. They saw a company that knew it had a risk and didn't warn the investors that it had a risk. And it turns out the management did kind of know they were taking a big risk with this, but they didn't warn shareholders. They would put it out in a proxy statement. They would advise their shareholders, look, we're going to push some social agenda things that may not be popular with our customers. We just want to let you know that. You can say that in a public statement. Companies warn about risks to their business all the time. It's a normal thing. What's not normal is when a company knowingly hides a potential risk when they're aware of it. And that's what they're getting sued over. In the meantime, this investor lawsuit came out of Florida. And Target was saying, hey, could we just change that to Minnesota? Could we change that to the state that's our company headquarters? Or even better, could you just dismiss this lawsuit? Like, we don't really want to get sued over this. And the judge decided, no, you're going to be in Florida. And I'm going to be your judge. And this case is going forward. And we're going to get all the details, all the discovery where you find out what actually was going on here. Coming from KSL.com, Target must face shareholder lawsuit over Pride backlash, according to a U.S. judge. And it really isn't just over the Pride issue. There are a number of things that Target did that they did not warn their shareholders about, related to things that are inefficient but are ideologically divisive. Things they knew they shouldn't really be doing, especially not without warning shareholders, but they didn't warn them, and they did do it. Target's been trying to get a little bit more normal lately, and that's fine, but they've still damaged themselves, and it's not getting them out of their lawsuit. From Washington Examiner, Target to scale back Pride collection availability to select stores. And right now, during the holiday season, also from Washington Examiner, Merry Christmas signs spotted at Target as Gay Santa is phased out. Yeah, they're not featuring Gay Santa the way they were trying to push that in previous years. And the Pride backlash is exactly why. Coming from Voz US, is this the Trump effect? Target ditches Happy Holidays and brings back Merry Christmas in store decorations. Target has realized that society has changed, and you just can't get away with pushing an agenda in every aspect of your business anymore. From America First Legal, who had a big part in bringing forth the lawsuit, victory. U.S. District Court denies Target's attempt to dismiss AFL lawsuit and transfer venue, that would be to move to another state, that would be easier for Target to deal with the lawsuit. Shareholder action against undisclosed risks and losses caused by Target's ESG, DEI, and LGBT Pride campaign to continue. And the reason they're citing ESG and DEI in addition to the gigantic Pride Month display campaigns they were doing is because it does show a pattern in practice. It shows they knew they were taking multiple risks and they weren't doing it in a way that protected the shareholders. And beyond that, they didn't even warn the shareholders they were doing this. How are you supposed to know what the company is doing if you're a shareholder unless they actually tell you? You're not there every day. You're not getting copied on emails. If they don't tell you they're doing something, you don't know what they're doing. And they don't have to tell you everything, but they do have to tell you when they're taking a risk that could dramatically affect the value of the company or the company's profitability. The U.S. District Court for the Middle District of Florida denied Target Corporation's motion to dismiss the shareholder derivative lawsuit titled Craig versus Target Corporation, filed by America First Legal. The court ruled the allegations in the lawsuit that Target failed to adequately disclose the risks of consumer backlash to the corporation's LGBT Pride Month marketing and sales campaign legitimately state a claim for a violation of federal securities laws. It's those securities laws that protect the investor. Disney has been warning in recent filings that they do push their political agendas, and that's what Target was supposed to have done. On August 8, 2023, AFL filed a lawsuit against Target and its board of directors for misleading investors about the market risks of a key corporate initiative, its environmental, social, and governance and diversity, equity, and inclusion mandates. The lawsuit alleged that Target embraced a radical transgender agenda targeting children and families through the corporation's infamous 2023 Pride campaign. AFL's lawsuit further alleged that the backlash to Target's 2023 Pride campaign led to billions in losses. And a loss of a couple of $1 billion here and there, even to a big company, is still significant, but it's not only about that. It's about the permanent damage to the brand. It's about the permanent association that the company has with something that their customers aren't really into. Maybe some of them are, but a lot of them are not. It makes people think twice before buying something from Target, and that damages the brand forever. Like the Bud Light situation, the association with Dylan Mulvaney is never going away. Target moved to dismiss the lawsuit and change the case venue from Florida, where AFL's clients reside, and filed the case to Minnesota, where Target is headquartered. In a groundbreaking decision, the court denied both motions, stating Target's 2021 risk disclosure could be materially misleading because it was not specifically tailored to the risks related to the plan for a new and aggressive 2023 Pride Month campaign. Target failed to account for the specific risk that Target's upcoming 2023 Pride Month campaign or previous campaigns championed by Target could cause customer boycotts and a loss of sales. And here's a part that's really devastating. The amended complaint, that would be the complaint from the people suing Target, alleges that Target knew the risks of the 2023 Pride Month campaign and failed to publicly disclose such risks. Generic risk disclosures are inadequate to shield defendants from liability for failing to disclose known risks. So if Target says, look, occasionally we may try different things, and that may not do so well with our customers, that's our general disclosure. That's okay, but when you know you're specifically doing a major program, and you know that that program has specific risks, you need to tell the shareholders so that shareholders can say, you know something, I'm going to sell my stock. You guys do this risky thing. I'm not going to invest in that anymore. I'll put my money in Walmart or another company. They didn't give investors that opportunity, and that's why they're in big trouble. Plaintiffs sufficiently provided facts showing that defendants' forward-looking statements about ESG and DEI risks were made with actual knowledge that they were false and misleading. Specifically, the court cited allegations by a confidential witness who held a senior marketing position at Target who said, quote, senior executives' decisions to undertake the 2023 LGBT Pride campaign and make it more prominent were deliberate, and that Target's corporate mantra now was to stick its nose so far out, even at the risk of alienating certain customers, and without thinking if the campaign went too far. Accordingly, the court found that based upon the facts presented, quote, it is plausible that the risk disclosures by Target related to the campaign were knowingly false. Due to boycotts against Target, the company lost $10 billion in market valuation between May 18th and May 23rd. That's $10 billion in like 5 days. With an overall loss between May 17th and October 6th of that same year of more than $25 billion in market capitalization. That's the value of all the stock put together. Target generally now is like a $60 billion company. Their stock is down about 10% over the last 30 days. That's about a $6 billion loss. A loss of $25 billion as a result of a risky promotional campaign that they knew was risky is really bad, and the CEO should have stepped down, and he never did. In denying Target's motion to transfer, the court noted that many of Target's directors live outside of Minnesota, and most of its corporate employees are required to come into the office once per quarter. That's once every 90 days, implying that many of them work remotely. Furthermore, Target's 2020, 2021, 2022, and 2023 shareholder meetings did not occur in Minnesota. For these and other reasons, Target failed to carry its burden in demonstrating that this court should transfer this securities litigation case to the District of Minnesota. And here's what America First Legal has to say. Quote, today's decision is a warning to publicly traded corporations, boards, and management. Our federal securities laws mandate fair and honest disclosure of the market risk created by management when it uses shareholder resources, including consumer goodwill, to advance idiosyncratic and extreme social or political preferences. The risk of ESG mandates and DEI initiatives, such as Target's Pride Month that targeted young children, cannot be whitewashed with boilerplate language or ignored. And the best thing about a lawsuit like this is it does put public companies on notice. And managers, they make a lot of money based on their reputation, based on their standing as, okay, well, this guy's been a CEO at this company for this long. He's been an executive over there. He understands what's going on. Wall Street respects what they're doing. But the issue is when they start going off in these crazy directions, that really isn't legitimate. That isn't professional, and it can damage people's reputation. Their reputation is why they get paid millions of dollars. And this kind of a lawsuit against Target is the new standard. It is groundbreaking. They weren't exaggerating. And we can expect to see more lawsuits like this one. This is the original lawsuit. In the United States District Court, Middle District of Florida, Fort Myers Division. Brian Craig, the investor, against Target, the executives, the board of directors, all use guys. Target Corporation, the self-proclaimed store of the boomer mom who drives a minivan and lives in the suburbs, and its board of directors betrayed both Target's core customer base of working families and its investors by making false and misleading statements concerning Target's environmental, social, and governance and diversity, equity, and inclusion mandates that led to its disastrous 2023 children and family-themed LGBT Pride campaign. These false and misleading statements caused Target's shareholders to unknowingly support Target's board and management in their misuse of investor funds to serve its diverse political and social goals and ultimately lose billions of dollars. The defendants, Target and members of its board of directors, have violated Section 14A of the Exchange Act and Rule 14A-9 and Section 10B of the Exchange Act and Rule 10B-5 by causing Target to issue proxy statements that falsely and misleadingly stated that Target's board and its communities oversaw social and political issues and risks arising from Target's pursuit of ESG and DEI mandates, adopted Target's ESG and DEI mandates in order to advance shareholders' pecuniary interest and value of Target stock, and proposed executive compensation plans that were aligned with the shareholders' pecuniary interest in the value of Target stock. This is a pretty serious accusation. They really had no right to do this. When you work for a public company, even if you started a public company and you own 80% of it, or even 90% of it, or 99% of it, if you're a public company, you have a responsibility to those individual shareholders. All they're asking for is to let them know what's going on and let them know, is there a risk that you're taking? If there is a risk that you're taking, maybe we can dispute whether or not you should or shouldn't take that risk. But if I'm a shareholder and I don't even know that you're taking that risk, that's really a breach of trust. You're supposed to be a fiduciary duty. You're supposed to look out for the people that put their faith in you, not make excuses for why you can use their resources for your own purposes. And that's what they did here. Target portrays itself as the store of working families. But as Target's formerly loyal customer base now recognizes, Target's board and management for years spent Target's valuable financial and reputational capital on the pursuit of ESG and DEI mandates behind the facade of Target's classic middle-class brand, all the while falsely and misleadingly portraying the risks of its strategy to target shareholders in order to secure its re-election and insulate itself from accountability. And that's another serious issue. If the board and the management aren't telling the shareholders what's going on, and the shareholders are voting and saying, okay, yeah, we want you on the board of directors, we approve of what the company's doing, then the shareholders are really being deceived into supporting people for the company that are making decisions that the shareholders aren't even aware of that are really risky. The lawsuit goes on to say, the defendant's misconduct began when, after defendant Brian Cornell took over as chairman of Target's board and chief executive officer in 2014, Target adopted several ESG and DEI mandates that materially affected Target's corporate strategy and business performance. Target was an early adopter of corporate LGBT initiatives, publishing a Pride Manifesto in 2015. A year later, Target became the central battleground of a vitriolic national debate over transgender rights after Target published an antagonistic response to North Carolina's transgender bathroom law. Target also adopted supplier diversity targets, including for a majority of certain collections to be made by LGBT creators and brands. In 2020, Target committed to an expressly race-based hiring plan by pledging to increase representation of Black team members across the company by 20% over 3 years through changes to its advancement, retention, and hiring plans. You really can't have a quota system in hiring and avoid legal scrutiny. That's why they're getting sued for it now as part of this lawsuit. It's also indefensible. You can't say, I only want white people working here, or Black people working here, or these women working here of this specific descent. You can't do that. If you do that, you're discriminating by definition. Companies, when they're still trying to do things like this, know well enough now not to be so specific with numbers, because it is a quota. It's very easy to define that and say, look, you're not hiring based on merit, you're discriminating based on skin color, we're going to sue you. So they're a little more careful now, but when they get caught, it's bad. Target also launched an ESG and DEI themed initiative called Target Forward that, among other mandates, committed Target to work toward ensuring that 100% of its suppliers have policies and programs to advance gender equity. Target experienced customer and investor backlash to some of those initiatives. For example, after Target's outspoken opposition to the North Carolina transgender bathroom law, several boycotts of Target were organized. And as noted by Fortune magazine at the time in 2016, it cost the company millions in lost sales and added expenses after shopper traffic and same-store sales started sliding for the first time in years, and the company was forced to spend $20 million installing single-occupancy bathrooms in all its stores to give critics of the policy more privacy. In December 2021, a Target shareholder sought an external audit of Target's, quote, overtly and implicitly discriminatory employee training and other employment and advancement programs. In Target's 2022 and 2023 annual proxy statements, the board assured the plaintiff and other investors that it was monitoring for social and political risks created by the ESG and DEI mandates that the board and Target management had imposed on the company. In reality, the board, both itself and through its applicable board committees, only acknowledged risks it perceived from failing to achieve its self-imposed ESG and DEI mandates. So the only risk that they would identify would be one that would be against them if they didn't achieve their ESG and DEI mandates, not the risk of how much damage it could do to the business by trying to do the ESG and DEI mandates. And those risks were actually in the billions. These risks were definably not social or political risks of ESG and DEI mandates, neither according to Target's definition, nor by how a reasonable investor would understand the phrase's meaning, but instead were risks driven by a select group of nonprofit organization stakeholders that Target worked with directly to adopt these very ESG and DEI mandates. Target knew their ESG and DEI mandates were a double-edged sword that risked backlash. After all, Target itself experienced significant backlash from its customers after Target became the face of corporate opposition to North Carolina's transgender bathroom law in 2016. Defendants knew that companies like Disney and Anheuser-Busch experienced immediate backlash to similar LGBT initiatives. Target knew that peer companies included the risk of backlash in their oversight of the social and political risks to their ESG and DEI mandates. It's one thing to have different political ideas. It's one thing to want to use the company to normalize things that are not normal in culture. But to pretend that those things are normal and accepted by the larger culture is something you could do on a personal level. You can't do it on a business level when you're holding other people's money. You can't pretend certain business realities don't exist when they really do exist. The CEO and the board of directors of Target may not believe there are only two genders, and that's up to them to decide on a personal level. But when they make that part of their business, when they start adopting slogans and behaviors that put the company at risk, it's not something they're allowed to do because it's not part of reality. At least without warning shareholders that they are doing this, that they're taking this political stance. And when they do that, they're breaking the law. They're violating their fiduciary duty to shareholders. They're aware of a risk and they're not telling their shareholders about it. And that's enough to get sued. And that's enough to get in trouble. And that's what's happening here. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another story. And if I don't see you, I will miss you.